If the Dormant Commerce Clause applied only to laws that facially discriminate against interstate commerce, it would be relatively easy to avoid. The court also, however, has invalidated state and local laws that are facially neutral but that have a discriminatory purpose or effect. Consider Baldwin v. GAF Seelig, Inc., a 1935 case. The statute at issue was a price support that protected New York dairy farmers. If milk was imported from another state into New York, it could not be resold if the price paid to acquire it was less than the price it would have cost to acquire from New York dairy farmers. This restriction did not ban the importation of milk, nor did it prohibit the consumption of milk imported from other states, but it did effectively regulate the wholesale market price by setting the price charged by New York wholesale suppliers as a floor. On the face of the statute, out-of-state wholesale milk producers were treated the same as New York producers, but the statute's purpose was to support the New York wholesale milk industry, that is, New York dairy farms, by preventing out-of-state suppliers from undercutting them on price. The court struck down this statute. It's difficult to formulate a general test for this category of Dormant Commerce Clause cases. This chart summarizes the cases in the notes in our text. In some cases, there may be indications in legislative history that the statute is designed for discriminatory purposes, even if it is not facially discriminatory. In other cases, the court may conduct a rough estimation of the effects of a state or local regulation on interstate commerce in relation to possibly non-discriminatory purposes of the statute, and may invalidate the regulation if the effects on interstate commerce are significant. This leads to our final group of Dormant Commerce Clause cases, which we group under the residual balance test, often called the Pike test, after the 1970 Pike v. Bruce Church case. The rule announced in Pike is that where the state regulates even-handedly to effectuate a legitimate public interest, and its effects on interstate commerce are only incidental, it will be upheld unless the burden on such commerce is clearly excessive in relation to the putative local benefits. Castle v. Consolidated Freightways Corp., a 1981 case, illustrates how the residual balancing test can be applied. An Iowa statute prohibited the use of 65-foot-long double tractor trailers within its borders. Other states in the West and Midwest permitted the use of such trailers. The Iowa statute effectively meant that Iowa dictated what kinds of tractors could be used on certain long-haul trucking routes, which as a practical matter had to run through Iowa, which is transected by Interstate 80 heading into or out of Illinois and Chicago toward New York or San Francisco. The statute was not facially discriminatory because it applied equally to intrastate and interstate traffic. Iowa argued that the statute had a legitimate purpose because long double trailers are more dangerous than smaller trailers. Evidence at trial, however, showed that double long trailers are at least as safe as single trailers. Based on this evidence, balanced against the harm to interstate commerce, the court struck down the statute. In a concurrence, Justice Brennan argued that federal courts should not use their trial procedures to determine or re-examine factual matters developed in the state or local legislative process. However, he believed the court properly struck down the Iowa statute based on its protectionist purpose. In a dissent, Justice Rehnquist, joined by Justices Berger and Stewart, argued that the court should only apply a rational basis review to this kind of legislative determination by a state. In essence, the dissenters suggested, Iowa was improperly forced to submit the autonomy of its state legislature to the judgment of surrounding states. The dissenters highlight an interesting debate about the Pike balancing test. Is it consistent with federalism principles that federal courts should be able to balance state legislative policies against burden to interstate commerce, even if there's no facial or intentional discrimination against interstate commerce?